And you're on.
I would like to bring the Pompton Links Planning Board meeting to order. Please turn off all cell phones. The following is the agenda for the regular meeting of the Pompton Links Planning Board. Meeting is to be held in the Municipal Building 25, Lenox Ave, on Tuesday, May 20th, 2025, beginning at 7:30 p.m. Formal written advance notice as required by NJSA 10-4-1 has been provided. This meeting at least 40 hours in advance of today, giving the time, date, and location, and the extent known at the time the agenda of this meeting. Such notice stated that formal action may or may not be taken. This notice was posted on the bulletin board outside the offices of Municipal Clerk, reserved for this and other similar announcements, provided to the Suburban Trends, the newspaper designated by the Borough Council to receive such notices and filed with the Borough Clerk. Please all stand for the Pledge of Allegiance.
Oh my God. There's something wrong with the view. I'm sorry. There's something wrong with the view. We're not on.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
You want to take a pause?
Yes, please. Hold on 1 second. Sorry, technical difficulties.
Resume the meeting. Oath of office, we have none. Could we have a roll call, please?
Okay. Mr. Simone is excused. Mr. Otto?
Here.
Mr. Trost?
Here.
Dr. Pendexter will be absent. Mr. Bowlby?
Here.
Mr. Keating?
Here.
Mayor Sarah?
Here.
And Mr. Bootsma?
Here.
We have Andy Brewer tonight, and there will not be any engineers, and Chris Foster will be absent. Good.
Regular meeting minutes for April 15th, 2025. Do I have a motion?
Motion. Second.
Roll call?
Paul and John?
Mm-hmm.
Okay. Mr. Otto?
Yes.
Mr. Trost?
Abstain.
That's right. Mr. Bowlby?
Yes.
Mr. Keating?
Yes.
Mayor Sarah?
Yes.
Mr. Bootsma?
Yes,
Were you here?
I wasn't here. I don't think I'm allowed to vote.
I wasn't here.
Abstain?
Abstain.
Come back.
So we're going to approval of the bills, Collars Engineering and Design,
You can just read the total amount.
professional services,
No, just read the total amount.
$3,826.25.
No.
Oh, I see the total, I see it down there, I'm sorry. 5,200, 5,213.33 cents.
And then
We have a motion to accept? No?
just keep going on.
Okay.
Each of the.
Oh, there's another one here, yeah. Merzia Falcon Legal Services, $1,448.40.
I'll make the motion.
Trost?
I'll second it.
Keating?
All in favor?
Aye. Aye. Opposed?
Okay.
Just in case.
Correspondence, memo from Elizabeth Brandisi, Municipal Clerk, Borough of Oakland, Ordinance 25, Code 963, an ordinance amending site plan and subdivision procedures. Applications, we have none. Resolutions, we have none. Conceptual, we have none. New and unfinished business.
Sure. Which is the presentation from H2M, which is our fourth round obligation. And I'll kind of set the table here so you understand what's going on. As you all may be aware, in New Jersey, there's something called obligation for towns to provide affordable housing, often known as Mount Laurel. It is a constitutional obligation which has been fought about, the details of it, for 40-plus years or so. It used to be that it was all in the courts, and then there was the COA, Council on Affordable Housing, that set numbers that everybody had to comply with, all the towns had to comply with. COA stopped being funded and went out of business. Then there was more fights in the court on what exactly this constitutional obligation meant. Very recently, there was legislation that was signed into law and is now what we're doing now. It's the fourth round, which is what will set every municipality's obligation to provide a reasonable opportunity for affordable housing to exist in the municipality. And so it parcels it out. It decides. San knows his stuff well. I've worked for Amendum, and she knows her stuff. She's going to explain it very well. But what goes on, and the process that was set now with this new legislation, which is a little bit different, is that there's a lot of very tight timeframes, and it is clear that the people that wrote this legislation were not land use attorneys, because of the timing. They have to have the agreement on what the number's going to be, and then there has to be a master plan amendment by this board, and then within 48 hours, the governing body has to endorse it, and it has to move on. So what towns are doing, and Pompton Lakes is doing, is giving you all heads up, because you do the master plan. So you understand where the numbers are, ask any questions that you need, any understanding, because next month, there will be an amendment to the master plan that puts this in place, that allows for it to happen. And so that now is just an explanation of what's going on. Next, once the number that is on the settlement is decided, now it has to be, the zoning will eventually have to change to allow that in certain places. In order for the zoning to be compliant, the master plan has to be amended to provide that certain areas would be good to have affordable housing and multi-unit housing. So that's what we're doing, making sure it all sets up time-wise. You all understand what's going on, what the plan is, what the thought is, what the settlement was. If it doesn't work and we don't do things on time, then the borough will be subject to a builder's remedy. What that means, as you may or may not remember from 10 years ago, is that if Pompton Lakes does not comply with the constitutional obligation to provide affordable housing, a builder can come in, have control of a piece of property, and because they bought it or whatever, and say, go to the court and say, I want to build 427 units on Wanacue Avenue in a 15-story building, because that will satisfy their unmet affordable housing need. And the court will say, sounds like a good idea. Yes, they'll take over the zoning and they'll do that. So we don't want that. So we're going through the process. That's what's going on now. I'm giving kind of a big picture. Son's going to give all the details and what the settlement is, what the numbers are, what the proposal is, but that's going to be the explanation. And with that, I will turn it over to Son, if that's okay.
So I'll just introduce Son. Son works for H2M, who we've been using for over 15 years to do our COA obligation. I call it COA, it's all different things. This is not something that we can do within our office. We have to hire professionals to do this, along with our borough attorneys and our planning board attorneys, to make it all work. So Son is the professional that we use to do this. It's very confusing. I'm amazed that she understands all the stuff that has to happen. You're going to hear a lot of stuff thrown at you. You have a question asked, but it can get a little confusing. So I'm going to pass it off to Son. You're off.
Thank you, Mayor. Thank you, Andy. So my name is Sanivita Chavan for short. I'm a professional planner working at H2M. I've been doing affordable housing for more than 20 years, the numerous iterations, and I still continue to do that. So sometimes I question, why am I doing it? So what I've tried to do here is to give everyone a brief overview and try to explain the process to you in simple terms. And I think Andy's preface about this is mandatory, we have to do that. If we don't comply and meet the deadlines, what that does is makes us susceptible to somebody coming in and saying the town is not meeting their constitutional obligation, here's my site. What adopting this plan does is provides us with an immunity. So I'm going to just go ahead and explain the process. What I did was, I do know there were screens here, but it's best if you can you have handouts, you can take a look at it if you can't see the screen. So basically the history, this has been happening for more than 38 years. There were different iterations, round one, round two, but the past 21 years with round three, there were numerous iterations, which finally, as Andy explained, that they had the Supreme Court abolished Council on Affordable Housing and gave the jurisdiction back to the court. So, originally from round one, two, and the prior iterations, the Fair Housing Act of 1985, basically, it was a legislative response to what we call as Mount Laurel cases, and it provided a foundation to establish this state agency called as Council on Affordable Housing to administer municipal compliance. And, it got abolished, and since 2015, so for the past 10 years, the courts have taken over. So we are assigned a court adjudicator, we are assigned a court, whatever is in our vicinage, a judge, and that's how we're going through this process since the past 10 years, and this year is no exception. I think so. So this slide is, I don't want to belabor the point, but it just provides that history for the past 38 years. And one thing good for us here in Pompton Lakes is, as the mayor said, notwithstanding whatever's happening around us, we continue to be compliant. So we are in a good, we are in a good shape today, which is great. And then I'll just go through the process to explain where we are today, okay? So I wanted to also give you a brief background of this new legislation, the A4 bill, which amended the Fair Housing Act. It was signed in last May, and it completely eliminated COA and put in a process where, as I mentioned, we have to go through the court. It created new processes. It updated a lot of the prior rules, and it assigned the Department of Community Affairs, which is a state agency, to allocate the obligation to provide what each municipality's obligation would be. And they passed the bill in March, wanted everything done before the end of the year, and the DCA published their rules in October 2024. They had very specific deadlines, which I'll go through. But before going into that, I just wanted to explain to you, what do we mean by housing regions? So we have 21 counties in the state, and the state has divided that into 6 housing regions. And what DCA did, or as per the legislation, was calculate affordable housing for each of these housing regions. I don't want to go into the details, but Region 1, which we are a part of, includes Bergen, Hudson, Passaic, and Sussex counties. Now, those counties are not similar to each other, but this is how the state has allocated us. Region 2 is Essex, Morris, Union, and Warren, and so on and so forth. We are in Region 1. We had an allocation which the state came up with a number, and which is, I'll go into detail, but it's a total of 150, 49 prior round and 105, which are the 4th round obligation. And 49 rehabilitation and the current obligation of 105 units. So what is affordable housing? So affordable housing is housing that is rented or sold or occupied or reserved for low and moderate income households. Now, you would ask, what is that? So what this whole process does is, based on your region, it determines what your median income would be and moderate income households are 80% of the established median income for a particular region. 80% is the upper threshold, going downwards up to 50. Low income are 50% of the established median income for the region. So basically, I included an income chart just so that you understand. For example, if you look, the median income, go all the way to the right, for a 5-person household is 130,000. Now, one wouldn't call that a moderate income by any standards, but however, that because it's a 5-person household, the way they write it, that's what it is. It goes down that line, somebody with a 5-person household, so husband and wife with 3 children, and if their household income is 104, that would be considered a moderate income, and I'm going down that list which you have in front of you. So this is again nothing we do, this is what has been decided throughout the state. They use HUD standards and other standards, and those thresholds are given to us. And this is more background so that you understand what it means to be a mod income or a low income. Now, yes.
Yeah, so, when they say the median income, and you're
Correct.
saying, you're referencing region, so that's for all those counties in the region?
That is correct.
Not just Pompton Lakes?
Correct.
Okay. Wow. Thank you.
Any other questions? All right, so, oh, did you have a question, sir?
No, I was gonna,
Same one.
same question, but he beat me to it, so.
Okay.
I just assumed they're lumping Bergen County with like Sussex County.
Correct, and that's why I prefaced that to say that this, your consultant hasn't done this, nor has your attorney done this. These are given to us by the state, and we have to follow it.
Okay, thank you.
Yes, go ahead.
No, thank you.
Okay. So then, what I also wanted to explain to you what are the deadlines that were established by this legislation, and what you see on the top was we've already gone through everything. We negotiated to have our number with DCA through the court. We are now at this stage where we have to adopt the housing element and fair share plan. And I also wanted to explain the roles and responsibilities, because typically you do the master plan, you make all these recommendations, and the governing body then based on that may accept your recommendations or not and adopt ordinances, right? In this case, so since you guys do the master plan, I'm very familiar with the process. Your land use plan forms a policy framework for any kind of ordinance. As per the state, as per the municipal land use law, your land use plan as well as your affordable housing plan, both of them form a policy framework. So basically, when we adopt the plan, the next step, the role of the borough council here is they have to endorse this housing plan element and fair share plan that's required by statute, but then they also continue doing what they typically do, like adopt ordinances or any supporting resolutions. But the reason why I'm even pointing this out to you, because that's a fundamental difference. When we have a master plan, the master plan doesn't get endorsed by the governing body. You make recommendations, the governing body will look at your policies and, so if you say recommend rezoning certain areas or whatever it is that your land use plan says, they just take your recommendations and they may either adopt ordinances or may just leave it at that. In this case, however, they're required by law to, once this plan gets adopted, they have to endorse it, and then it gets submitted to the court. So that's one process which slightly differentiates this plan from your typical master plan. Right, Andy? So, moving on, so once we submit this, and we have 2 months until there is somebody who wants to contest it, they have the right to do so. I mean, this legislation has been far more, I think, clear as to who could. In the past, anybody could come and say, we don't like your plan, but now they have to have a solid reason. So which I think would work in favor of municipalities who are proposing a plan that, you know, will address their affordable housing obligation.
Right. Jump in just a little bit.
Sure.
The squares that weren't there, and you probably got it anyway, but what's happened up to this point?
Oh, I'm sorry. Yeah.
Oh, no, what's happened up to this point is what she said. The process that happens generated a number. And then Pompton Lakes, like every other municipality, got to look at that number and say, do we think it's right? Can we challenge it? They're going through the process, so we're immune from a suit, but you can say, no, we think it'd be a different number. They worked out, so the borough council and the planner and the attorney who's representing them in that stuff went through that process and now has the number. So they got a number, and now it's putting it in, so that those steps have been taken by the borough, and now it's going forward with some more steps that need to be put in place. But I didn't mean to interfere, but.
I'll just jump in. We've had numerous, just what Andy's saying, numerous meetings
Yeah.
with Son and Michael and myself and others about to get to this point where we are. So this doesn't just happen today over this. This has been going on for a year.
And to go back, I mean, Andy and I were talking about this before the meeting, you know, having done this for so long, this is the first time they're trying to squeeze, the state is, you know, trying to make us do this within 5 months.
Tight time frames.
It's a very tight frame, and, you know, we're doing our best to be in compliance. So, moving on to the next slide. So this, again, just trying to highlight where we are. So, what is your affordable housing obligation? What does that mean? So, an affordable housing obligation typically gets divided into what they call the present need and the prospective need. So what present need or rehabilitation component of affordable housing is based on the census data, based on the state, DCA in this case, says, okay, you as in Pompton Lake, out of Housing Region 1, you have over 45 units that are estimated to be over 50 years, or some of them may lack complete plumbing facilities, this and the other. And it's all based on census data. What that means for us is we don't have to rehabilitate all the 45 units as a part of our plan. We say, okay, state, we understand we have that obligation and we have programs in place. And the state has always had, it's part of the Bergen County, and we also have a private consultant who's helping out. So what that means is if we need to rehab, somebody who's income qualified says, oh, I need to get my roof replaced, they could go to Bergen County and do that. So, you know, we as a town don't need to actually have to sit and plan for this. This is just that we acknowledge it and have mechanisms in place. Does that make sense?
Mm-hmm.
So the next part is, what is prospective need? Prospective need is basically what is called as your new construction obligation. So what that says is, okay, for the time period from 2025 to 2035, the next decade, so these obligations, each round is for 10 years. So your obligation, Pompton Lakes, is 105 units. It's 105, it's your share out of that region of 4 counties. Okay, so that's what they have given that to us, and so that gives our total obligation 105 plus 45, 150 units. Is everyone with me, or do I need to explain?
So this 105 has to be built.
No,
Yeah.
I'll go there.
Okay.
I'm going to go there. This is what, so the legislation puts in your obligation, but there are other things, like a town like Pompton Lakes is completely built out. So I'll go into the next, so that you understand what are the next steps for us. So the legislation also requires, as you guys do so much, the MLUL tells you what constitutes a land use plan, where we, talk about land uses, we talk about stormwater resiliency since 2021. We've been, we have these kind of requirements. The Fair Housing Act has a language as to what constitutes a housing plan element. Okay, so we look at census data, we look at your inventory, we look at projections, we analyze your demographic characteristics, very similar to what we do in a typical master plan. And then we also determine what is your present and prospective fair share. So we write a housing element, which is very typical to what we write in the master plan: demographic analysis, housing analysis, employment characteristics. But we also write, okay, state, you're telling us we have to provide a plan to meet our obligation. This is how we are going to do. So, so basically, we have to follow what the legislation or the statutes want us to do. And I'm just providing this because when I come next month to present the plan, this gives you all a background of what that plan is all about. Again, we're in the 4th round, and we are planning for the period from 2025 to 2035. So then, going back to your question, I think, can we really plan all the 105 units? Do we have the land? Can we even do that? So when there's a municipality like Pompton Lakes, which lacks sufficient developable land, we don't have vacant land, we did an analysis, right? The statutes allow what we call as adjustment, a vacant land analysis, a vacant land adjustment. We actually go through, we've already done this process, so we go through the process of identifying if you have any vacant land which is class 1 property, or any public land that is not encumbered by like wetlands or within your open space inventory. We identify this to see if you have anything available. And this is not just for Pompton Lakes, that's a requirement standard across all the municipalities in the state of New Jersey.
Happen real quick, just so you know why this analysis has to be done. This is a rough explanation of how these numbers get allocated to towns. Imagine something like a Google Earth picture or a satellite photo. They look and they see how much green space and undeveloped things does there appear to be. Well, that's how many acres. You could take 105 units.
Correct.
And now someone has to go through the process and say, no, that's a park or a swamp or something else that they can't. So that's what's going on. But the initial number is one step, and then
correct.
That's what goes on.
And so which actually, going back to Andy's point and everybody asking this question, where are we going to put this 105? We don't have vacant land, right? So, so once they give us this number, we identify how much, a land is truly available. Okay, this is a park, get that out, that's wetlands, get that out. And then we actually see what they call as a realistic opportunity. So it's called a realistic development opportunity, or RDP. So when I actually do the presentation, I'll be throwing a lot of RDP, and this is what RDP means. So Pompton Lakes, when we did this analysis, it has no vacant land. You all know this, right? So your RDP is 0. So the 105 units is what they call unmet need. So what that means is, okay, we hear you state you want us to take our share of the region, which is 105 units, but we have zero land to accommodate that. So the statutes also then allows us to get credits for, you know, work that, or housing that has already been built, or rezoning that has already occurred, or, you know, identify areas saying, okay, should we need, we can accommodate some of those units here, or we can have a development fee ordinance in place, which we already do, or we can have a mandatory set-aside ordinance, which basically means if any development results in 5 or more units, 15% of those would be affordable if it's a rental, and 20% would be affordable if it's for ownership. And the town has already adopted that ordinance, as have many municipalities, because it sort of provides us with that protection that nobody can say, okay, town, you're doing nothing. You know, so we have mechanisms in place, which is a good thing if you've always been in compliance like Pompton Lakes has. So what we are trying to do in this plan, it's still in a draft format, but I can give you an overview of it. So we're proposing a plan to create an opportunity for about 25% of these 105. What we did is, the statutes talk about mechanisms in place. So some of it is a minimum family housing, you know, so 25%, we're thinking around like, let's try and satisfy at least 27 units through something that is already existing, or, you know, something that could be realistic. And one of the things that the statutes has done in this round, which is going to be helpful for us, is that the maximum age restricted is 30% of the total obligation. But now we're talking about 27 units, so 30% of that is 8 units. So, you know, we have zoning in place for family housing. We have everything in place right now. It's just a matter of applying that to the 4th round. So am I going too fast, or everybody's clear, right? So these are...
I just have a question.
Sure,
really
sure,
quick.
go ahead.
So I saw earlier on that the amounts that we need, projected future need, is 150. However, I see that the required units, or the unmet need, is 27. Can you just really, simply say how you got to that?
I'm sorry, what?
How we got to that?
Yeah, definitely. So I'll explain myself. So, you know, our obligation is 105. We don't have vacant land available. So we're looking at the vacant, we are looking at what we call as realistic development potential, and it's 0 because there's nothing available, right? So then what happens is we have 105 unmet need. Okay? What we are doing right now is we are having something in place for, it's actually, I wrote 27, but it might be more than 27. But it's just that we're having mechanism in place for at least to address, like realistically address what's 27%. The rest, we have other options. So we are not saying that we're not going to do the 105. We are saying that we have zoning and we have opportunities in place to address 25%.
Okay.
Make sense?
And that's through state statute.
It's everything's through the state statute. So,
And just so you also understand, the affordable housing obligation is not an obligation to provide built units. It is provide a realistic opportunity to have the affordable housing there. So the solution, what we have to do isn't build them, 105 or any other number. It's to have a realistic opportunity for them. So if you had zoning in place that had lots of vacant land and it was multi-unit housing, you're good. We don't, we have, quirky stuff, there's no man, but it is, to some extent, the state and people in the courts that look at it are gonna say, yeah, this number that you got applied was 105, clearly there's no way it could happen. What's the realistic opportunity that something could happen? So I think that's what's going on.
On the opposite side to that, if you look at Wayne has the open space and the open land. That's why you see all these things being built, because they're trying to meet their obligation, because they don't have the 0% like we do. They have a number and they gotta build
So
it.
it really just has to be included in any new building, not mandatory.
Correct, so.
Opportunity.
Right, so like, for example, in Pompton Lakes, for example, if somebody's building an apartment over a commercial, for example, right, and they're putting in 4 units, we have in our ordinance that if it's 5 or more, you have to provide 15%, so at least 1 unit has to be affordable. If it's less than 5, so 4, 3, 2, what we have is a development fee, a residential development, which is 1.5% of the equalized market value that you pay at the time of CO. So, but what this ordinance does is, if anybody who's looking at our town would say, okay, this town is doing everything to provide, mechanisms to address their affordable housing need, which is what this ordinance, which I think you guys have had it for at least 10 years now, right? So, I'm just trying to provide an explanation, because I don't know if all of you were there 10 years back,
It's
so.
the number one question a builder when they're coming into town asks, first question, what's the COLA obligation?
Yeah.
They like to know what the COLA obligation is. Before they do anything, they don't ask anything else, they want to know that.
What about pre-existing?
Pre-existing, what do you mean by pre-existing?
Well, we had 42, Lakeside's 42 units, 52
So-
units?
No, they have COLA.
They have.
But I'm just saying, they have units already there. Do they count towards
They
the
come into the
105?
prior rounds. We
So anything from the prior rounds don't count
We don't
from this
double
time
count it.
going forward?
So, and,
What
right.
about this place over here?
But most of everything that has been in existence in the prior round, we've accounted for in our prior round plans, right?
Anything that's being built or in the process of being built. prior
Meridia,
rounds.
we don't get credit for that in this 2025 to 2035, that's the prior round.
It's a prior
That
round.
satisfied our prior.
Even though it's not built,
Correct.
finished?
No.
It doesn't, we don't.
When we signed off and got our immunity years ago, we essentially, as Bob Blake said, when Meridia gets built, there's gonna be this many affordable units, so we didn't get sued. So that was a promise that kept us from getting sued, 8 years ago or 7 years ago. That's out the door, that has to be those affordable, this is what
And
goes
this
on
suit,
forward.
just so everybody understands, the remedy lawsuit thing is an important thing, because they win these cases. They go to court and they can win these cases, and then you're building things you don't want in town. That's what's happening in Wayne, actually. A lot of those remedies are built, and they have no say in it. They can build whatever they want as long as the court says yes to it. So that's why we're trying to stop that by doing this obligation. If we don't, we could get in trouble.
And this, and I want to, I want to emphasize the fact that what this plan does is that we have a full control over our zoning. So nobody can come and say, let's put in a 10-story building, or, our zoning stands. So moving on to what are the mechanisms. So, like I said, in our prior plans, we thought ahead, when we wrote our plan. So, for example, Pompton Lake Senior Housing, right? If I go back, 30% of the 27 is 8 units, right? Pompton Lake Senior Housing, a total of 99 units are built there. 91 already we've taken credits for the prior round because of the senior housing. So we couldn't avail of that credit in the prior round because there was a cap. You can't exceed a certain number, because if you don't have a cap, what the state is worried, or that people will just put more senior housing and less family housing. So that cap, out of the total 99, we could only avail of 91 credits. So that opened up 8 credits. So we are thinking, okay, 8 credits we can apply towards the unmet need. We had done the Tilco site rezoning, which is the existing quarry, we had done, calculated that in the prior round and said, okay, we are going to use this mechanism for the unmet need. So, we had calculated around 27 units when we wrote the third round plan. So what I did was I studied the third round plan to see how much of that is extra that could apply to this round. So we get a total of 35 units. And then going back, the statutes, right, like I said, some zoning, you're required to have some zoning standards in place. You need to zone areas. So tomorrow, if they get redeveloped, they can provide affordable housing. The second thing is another mechanism we have in place is mandatory set-aside ordinance, which I just spoke about. Like if you're building 5 or more units, and it's all rental, 15% of that goes towards your affordable housing. So they would continue to, should that development happen around the town, in the future, in the next 10 years, they would go towards our unmet need. Secondly, since I think since the second round, so it was like around 1999, 93 to 99, there was something called as a development fee ordinance. So what that means is that if somebody were to do a development, like build a new house or subdivide their property and build 3 or 4 houses, or do a residential development, a percentage that is set by the state statute goes towards affordable housing. So you're required to have a trust fund and deposit money in that. So that's called a development fee ordinance. Towns are required to first have an ordinance in place and then correspondingly establish an affordable housing trust fund. We've had this for the past 10 years, I would say. So, so we are satisfying that mechanism as well. So I think I'm at the end of my presentation.
So it's the hardest thing, and the hardest thing for me to comprehend, when she's talking about where we're getting units, these are ideas where we may be able to put units. That doesn't mean we're going to build them and put them there. This is just space that's been set aside that maybe someday units could go there. So if I know she's going to go to the last page, and it's actually Tilcon, not Tilcon, but we're identifying that as open space when they leave the quarry, that maybe somebody's going to build there in the future. That's saying that that's not going to happen. We don't know that. There's no set plan for that. But we're identifying that as an area that could meet some of our requirements. It may never happen. We identified on top of Lila, years ago, to build apartments there. That never happened, but it helped us get to some of our numbers. So,
Right, and and Pompton Lake Senior Housing, we already have that. So that's a real. It's already there. So we are going to get credit that 8 units would satisfy our unmet need. So I'm at the end of my presentation. I thank you all for your time, and I'm ready to take questions if you have any.
And get any credit for the senior housing that's
yeah,
going
we're
on?
talking about that because we're going to try to sell it as a vet. See, it's vets first. That is what it's for, which is a little different, right? And you can speak to that.
So I haven't prepared the final plan to discuss at a public meeting, but our goal is to avail of every opportunity we can, so that whoever reads our plan understands that we are not only just complying because we have to, but we have been complying because of, towns that actually have been doing this kind of work, having affordable housing. It's easier for consultants like myself and Andy to defend these plans or, and put in the necessary documentation. So I think what the next step would be, at your next meeting, I will have much prior to that, by June 6th latest, an affordable housing and fair share plan that, of course, I will send it to Carmelina. She will have it on file, as well as distribute to the planning board so everybody can read it, and then I will do a similar presentation for adoption that night.
And that's a part of your master plan. That's an element of the master plan. So it's a master plan amendment. So it gets noticed, and there'll be a resolution that night, hopefully, because in order to stay in compliance, has to be done, and a few other things by June 30th. There'll be a resolution adopting that housing element and fair share plan.
And I think because...
And that's why everybody encouraged questions, because you and the borough council have to be in agreement, because sometimes, master plan can come up, take a while, no, we want to make some changes, and go up to next month. That can't happen. We're going to be in trouble if that happens, which is why it's encouraged that you ask every last question, make sure that everybody understands this, there's not a lot, it's going to be putting zoning in place to allow for it. That's really what's going on.
And builders
Yes.
are looking to file that
Yes.
suit the day after that
Yep.
change is due.
So ask
it's
any
not like
question.
there's any time frame. The next day, there's people knocking on the door saying, we're gonna build a 75-story building.
Ask any question, because next month, we're going to hope to also ask questions, but for there to be adoption.
So I have a couple of questions, and
Sure.
thank you, by the way, you've made it extremely clear what our process is going forward, and I think I have a very good background after the presentation that you gave. I just wanted to look at the mechanisms part, because it looks like these are, two of our options, but I know that, sometimes options fall through and you might need alternatives. So first, I just want to ask, clarifying, so you said that the Pompton Lake Senior Housing has already been used towards quotas in the past, correct?
No.
Okay.
Let me explain. The Pompton Lake Senior Housing had a total of 99 units.
Okay.
Because the prior rounds, so the first, second, and the third round, the prior rounds, there was a threshold of 25%. So, we don't need to relitigate that, but 91 of those units were satisfying the prior round obligations, and the town could not take credit for all the 99 back then. So we have 8 credits or 8 units that are available today.
Okay.
So those I'm applying towards this. Then the prior round, the prior plan, we also have spoken about the Tilco rezoning to address the 4th round.
Okay.
So we had done an analysis and said, okay, we have 27 units that can get generated there. We're using that towards this. The statute also allows, when there's an unmet need, to have what we call the mandatory set-aside ordinance. This is chapter 190, if I'm not mistaken, of your ordinance.
Yep.
Right? So we have that in place, which is a mechanism as per the statutes, like the statutes allow us to do that. So I'm listing this so that you as the board have an idea of what I am going to put in the plan when you see it next month. Because the next month when you see it, and you've read this 10 years back, it's a very complex and a dense document. And I wanted to simplify it so that you understand that if I put in all this demographic information, I am required to do by the statute. And really what I would, again, you can read everything you want to read, but, and Andy, please correct me if I'm wrong, but I feel, what the main decision that you would take on, that you have to take on, is the fair share portion of the plan, because based on that, if there's any, and I think Tilcon was already rezoned to H, if I'm not mistaken, so we already have the mechanisms in place. I would say that, that's all we're going to apply. So I guess that's it. Does that answer your question?
I guess it does. The roundabout thing that I wanted to get at is I see one of which is a new zone and one of which is existing. And so I was just going to ask if you have any other resources.
They're all existing. None of
All
it is,
existing, okay.
yeah. Because that's what I was trying to say, is that towns like Pompton Lakes and a few of my clients who've actually always complied, it's not such a heavy lift. And I'm sure Andy would agree with me too, with some of the towns that have constantly been, right? So when you have mechanisms in place, it's like, okay, we have this mechanism in place. We didn't use it in the prior rounds. We're going to use it now. And it's well within our right to do so.
So maybe to help you answer your question, say a developer comes into town and he has an idea of a project in an area that we take up. He says, I want to build 20 units there,
Yeah.
and never builds it. I then bring that to her and say, well, somebody did show interest in this space for 20 units. So that becomes part of the plan now. Maybe it gets built, maybe it never gets built, but it's part of that plan at that point.
I understand the process. I was just asking, are there any other places like?
Sure,
the-
identify.
Okay, got it. And that will be
Yeah.
identified in the next meeting.
Yeah, so should there be, we may not need to, I think we have a very good plan in place, but yes, should there be, we'll definitely identify that.
And that's all I wanted to know.
Of course.
Yeah, and essentially what's before you is, this is what is in her reason and our reasoned judgment will be acceptable. We're not gonna build 105, that's not gonna happen, but what will be acceptable based upon all the constraints and changing some zoning, Tilcon zoning, and the fact that we couldn't, you can't use all those age-restricted ones before, so we have a credit, so this is something that would comply. And that goes back to my original beef that everybody had with Mount Laurel, is that the court said all towns have a constitutional obligation to provide a reasonable opportunity, but they never once said what the number was, and we've just been fighting about it. So
Yeah.
that's what this is. The court still hasn't said what it is, but now we have this process in place, and there's a reasoned judgment that this will be acceptable.
And every town in the state of New Jersey has to do this, by the way.
Everybody.
Correct. And
I'm
those
gonna see Son tomorrow.
who-
End of-
yes. So, I don't think I'm going to
No.
come next month.
Okay,
So we'll talk later.
So you got it.
Yeah.
I'll see Son next month. Yes.
So, back to your comment, Mayor, you said that, say a contractor comes in, after this is put in place, say in September, and they want to build 20 units. We've already satisfied with this, so those all 20, the answer is none of them have to be.
No, they could be used, there'll be another round, 10 years from now.
Right, no, but I'm saying in September, so they want to build 20 units
Yeah,
somewhere in
if Son
town.
identifies the need that we have,
Right.
then we're filled, we're good. We don't have to identify anything.
It
Right.
does not have to be, it could be, and then it would be benefit us in 2036. That's
Right.
right.
36.
Yeah.
Right, 10 years from now.
That's right.
Because I would bring attention to the fact that whatever we did 10 years ago is benefiting us today.
Right.
So whatever happens 6 months down the line and somebody comes up with something which is reasonable in compliance with whatever mechanisms we have set in place, like for example the mandatory set-aside ordinance or what have you, if we don't use it now, Fifth Town we can use.
Right. So, but in the master plan going forward, will it have a percentage number that we'll have to decide on that 20 units?
We don't really do that, it just talks about where, those are the things that are really gonna be in the master plan element that you're gonna see.
Okay.
What's being proposed, as she said, there's gonna be statistics and census data and other
Yeah.
stuff, but what's being
What's
proposed
the
to
answer?
change, is those things should be available. Other stuff is already in place, so you don't have to change it, but the master, sorry.
Okay.
Yeah, no, you're not interrupting me. And just so that you understand, so if, say I'm a developer, right? And I come up with these 20 units you're talking about, and they're all family, so I'm saying 20% of this will be affordable. I will come to you with my engineer and planner and architect and do a testimony. If it's a variance-free application, by right, I get approval, and then you're going to say, okay, I would like you to use an arborvitae here, or whatever that is. But then when it goes for building permits, and then it goes for resolution compliance, and then it goes for the other steps, that's when, Andy, when he writes the resolution, he'll put language in that out of those 20 units, 4 units have to be affordable. So whoever is doing the resolution compliance, and then you're construction official, when he's giving the CO, he'll talk to, I think, Triad is talk to Triad saying, okay, we have 4 affordable housing here. So then Triad will say, okay, so whoever goes, that would be income qualified. So then in 2035, you would say, oh, that 20-unit development on Wanacue, we're getting 4 credits towards our 5th round.
So Triad, just for people who don't know, is the company we use, our professionals that we use to verify that the income and all the requirements needed to get in to the COA is met. So we have to hire professionals to do that also, to make sure they meet the requirements. So Triad does that for us. Now, saying that, who's paying for that? We've been collecting funds, like Sam mentioned, for the last 10 years on some of these offsets. They didn't get 4 units, they've got 3 and they bought out. So we have probably over $160,000 in this account that can go to rehab some houses that need help, or to pay some of these costs for the administration side of it. There's a percentage you can use for the administration costs. So we do have an account with money in it that can only be used for certain things. But some percentage of that can be used to pay off something like a Triad or something like that. But I don't know if that helps or hurts, but.
Okay.
That's it. Anything else from the board?
No?
Thank you, everyone, for your
Thank you.
time.
Man, Son, thank you.
Thank you, son.
Thank you.
We have some other new business here. We have the board to discuss a recommendation to the council for a change in ordinance regarding the correspondence from Township of Wayne dated April 17, 2025.
Mr. Chairman, if I could make a comment on that?
Please, John.
All right. So, last month, 2 of the memos were from Wayne Township. One of them stated, no structure containing a non-conformance use shall be modified, and went on to the whole thing. My only question is, it made sense, but it seemed like this is kind of late in the game to kind of come up with that, because it seemed pretty obvious. So I'll ask the question to Pompton Lakes. Do we have that in play? That was my question.
What was this, I didn't actually.
Yeah. So it's
The air conditioning is out in my building, and so I've not been in there in 2 days. But some documents that I normally have, so it's been a little administratively difficult, so I didn't get a chance to read it.
Got
What
it.
is
So
it?
again, it was last month's memo. It just said, no structure containing a non-conforming
Thank you,
use.
son. I'll talk to you.
It sounds like cannot apply for any kind of modification change until they get the proper use in place. Which seemed obvious, if they're sitting in a business use and they're not a business, but they're looking to expand, they shouldn't get a permit, But if they just Wayne just put it in last month, I'm kind of hoping we would have it. So I guess the question is.
It's really an element of the municipal land use law. If there's non-conforming use and you expand it, that's a D variance. They'd have to go to the Board of Adjustment anyway. You can't, so even if you prohibited it, that's exactly why the Board of Adjustment exists, to give use variances. So it's really within the municipal land use law, but I'd have to see exactly how much they're trying to restrict it. I can do that next month. I'll read it better, and I'll give you
Sounds good.
But I could compare it to, what we have, to what they're writing, but generally, they'd have to go to the Board of Adjustment anyway.
Got it, okay. So, and the second one was dated photos. Whenever we get any of the applications from the building department, first thing I do is Google it and then see what the picture of the house, the property, the building, whatever it is. It would almost make sense. Wayne put it in as a requirement for their submission. Maybe we should do the same thing to kind of make it easy for everybody on their review process.
I've heard that other places. I think it's, to the extent you want my advice, I think it's a good idea. It has to be done by, as you know, done by ordinance, because that would change basically the checklist in the application, but I think it's a very good idea.
So you guys would make a request to the Borough Council?
Yep. To change the checklist, make that a requirement.
So if that's something you want to talk about, or at another time, you put a written request in to us.
Okay. All right. I'll talk to the chairman.
Yeah, and you give your reasons.
Yeah.
Why you want to.
Okay, sounds good. That is all I have. Thank you.
Any other questions from the board? I'd like to open up public discussion, if there's any. Seeing none, we'll close public discussion. Have a motion for adjournment?
Motion.
Second.
I'm sorry, who was that?
was Tim
And Paul?
and Paul.
All in favor?
Aye.
Opposed?
That meeting I've had 10 times over.
Opposed, carried. Done.